Please be seated. We're ready for argument in 23-376, Fossil Group against Harris.
May it please the court, Mr. Barkas will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
Mr. Chief Justice, may it please the court. This is a case about workplace sexual harassment and whether and when an employer without contemporaneous knowledge of the misconduct may nevertheless be held liable for it. It depends in part on whether the harasser was a coworker or a supervisor. This is an issue in dispute below. Fossil sought and obtained summary judgment under both theories of liability. The Court of Appeals reversed that summary judgment and did so entirely on the basis of testimony by Ms. Harris that she believes she sent an email reporting the behavior a few days before she resigned.
Was there another report of the behavior made around the same time as Ms. Harris's report? There
was no other report of behavior towards Ms. Harris other than one that was made in the a few days after she resigned.
Yeah, so within the week, right? Because
Sure.
hers came about the week before and this one came
Correct.
within the week. And,
Exactly.
And that report said, I was harassed, and so too I think Mrs. Harris was
That's
harassed.
exactly how it works.
So should it matter?
No, it shouldn't. Even if she sent that email.
Shouldn't it matter whether Ms. Harris sent a report if there was already another report around the same relevant time frame?
Correct. The right thing happened. Even if Ms. Harris sent the email that she says she sent in late April, which is certainly not proven and is disputed at most, other reports came in, including reports about conduct towards her and about conduct towards another employee. Mr. Brown was gone by the end of the month. He's fired, right? The prompt remedial action was taken in response to reports of sexual harassment. And
Is this a state law claim or a federal law claim or both?
This is pleaded solely under the TCHRA. This was not pleaded under Title VII. The same standard applies, though, Your Honors, as this court has made clear in many prior cases, because one of the stated statutory purposes of the TCHRA is to implement Title VII. Cases construing Title VII are applied frequently in this court in interpreting the TCHRA, which is what the court should do today. I want to discuss the elements of both coworker and supervisor harassment, but the focus is only on the final element of coworker and on affirmative defense that this court should recognize and apply.
Why wasn't he a supervisor if he was in fact the assistant manager of the store?
He did not have responsibility for example, hiring and firing. He had some level of managerial authority. He wasn't just an employee. But he was not the store manager with responsibility to make personnel decisions. It was certainly a disputed issue below. For today's purposes, it doesn't matter. There's no liability either way. And to that point, let me talk first about coworker harassment. 5 elements of a prima facie case of coworker harassment are that the employee belonged to a protected group. That's undisputed. The employee was subjected to unwelcome harassment. We certainly assume that to be true. Harassment was based on a protected characteristic. It was based on sex. The harassment affected a term or condition of employment. It did, although it didn't result in a tangible employment action.
Doesn't the labor code separate, and I may not be remembering the statute correctly, but my recollection is that the labor code separates out sexual harassment and has particular provisions about it. That it does not state with respect to harassment on the basis of some other characteristic.
It does now, and it has, as of 2021, that's absolutely correct. This behavior occurred in 2018 and 2019, and that provision of the statute does not act retroactively. So this case was brought under the normal provisions of the labor code, not the later amendment to add specific sexual harassment.
And those normal provisions of the labor code don't mention the hostile work environment.
It is just a species of discrimination based on sex.
That's what the courts have said, but the legislature hadn't quite said that until it made the specific provision for
Correct.
Sexual harassment.
Correct, and that was 2021.
So you went through the 4 that were undisputed, but you didn't get to the 5th
didn't.
that is disputed.
So the 5th element of a coworker harassment claim is whether the employer knew or should have known of the harassment and failed to take prompt remedial action after gaining that knowledge. Now, when the alleged harasser is a supervisor, that fifth element falls away, and in its place, at least under Supreme Court and federal precedent, the Farragher-Eller defense arises. And the burden shifts to the employer to show that it exercised reasonable care to prevent and promptly correct sexually harassing behavior, and then shifts the burden back to the employee to show that they reasonably failed to take advantage of that program. If the employer proves that the employee unreasonably failed to take advantage of those programs, the affirmative defense shields the employer from liability under the Farragher-Eller defense, which applies again only to supervisor harassment. On coworker harassment, as I said, the first prong of that fifth element is whether the employer knew or should have known about the behavior being perpetrated, in this case by Mr. Brown. And that can take the form of actual or constructive knowledge. The Court of Appeals discussion and decision on this element was focused solely on Ms. Harris's testimony that she believed that in late April, a few weeks or perhaps a few days before she resigned her job, that she sent an email of some sort.
Well, she didn't say I believed in her deposition testimony. She said, well, I did send out a statement. I never heard anything back. And then you asked her, or someone asked her, tell me everything about the statement. And she said, I'd have to go back and look at my emails. But pretty much I explained what was going on. I stated Mr. Brown's full name, and I stated my name, what store I worked at, when I worked there, and what basically took place. So I don't think you can characterize her testimony as a statement of belief. Later, she couldn't find the email, and she says she, her counsel, her attorney, in response to motion for summary judgment, said she believes she sent the email.
Correct.
But that doesn't, it's not like a sham affidavit where in one place the witness testifies the light is red, and then later walks that back and says, oh no, the light was green. This is, I made a statement, and then later says, well, I believe I sent an email, I can't locate it. So why would we discredit that deposition testimony as a matter of law?
Well, you would discredit it because she did say later in that testimony, do you still have a copy? Yes, I do. That turned out to be incorrect at minimum. The good news, though, is you don't have to discredit that testimony to decide this case in favor of the petitioner. We can assume that Ms. Harris sent an email in late April, as she claims to have done, describing conduct perpetrated towards her by Mr. Brown. That puts Fossil on knowledge in late April. And to the prior point, Fossil certainly had knowledge of the behavior towards Ms. Harris when it reached out to interview her after she quit. And another employee on May 4th came to Fossil and said, hey, I think Brown was harassing Ms. Harris. The store manager the same day picked up the phone, called her, got the details, asked her to come in for an interview the next day, got more details, reported it to HR, and the guy got fired. So even if Fossil knew or should have known in late April based on the email, if we make that assumption, the prompt remedial action element is where this case turns. Ms. Harris did not have evidence that Fossil did not take prompt remedial action, and the evidence in the record is all to the contrary. The record, for example, as I said, contains evidence, and it was secondhand or even third-hand reporting other than the email. But in response to that second or third-hand reporting, Fossil sprung into action, and that's what it was obligated to do.
So if that had not happened, if the case didn't involve that additional complainant who led to the investigation, instead we have only the part that Justice Bland quoted to you, would you still make the argument that her testimony should not be credited?
I would, Your Honor, because her testimony is that she believes she sent an email. She described that email in detail.
But
she
Justice
didn't
Bland
use the
just
word
read the deposition, which was more definitive than that.
And it's hard to separate what she said and her lawyer's gloss on it. The description believe comes from Ms. Harris's counsel explaining her own testimony. But regardless, her testimony is, I sent this email and I never heard anything back. And again, assume that's true, perhaps there would be a fact question. That isn't all that happened, though. Even if she sent that email, the things that happened within the rest of that week prove the point, prove that Fossil took prompt remedial action when it did have notice and got rid of the guy.
But again, in the parallel universe in which none of that actually happened, you think that there would be a fact question. It would not matter that, for example, she couldn't produce it, that you did a search of your emails and didn't find it. There's no allegation, as I understand, of spoliation. Would those things still lead to a fact question, or do you think you could prevail as a matter of law?
I think there's a possibility of prevailing as a matter of law, certainly in light of the evidence we did put in the record that there was a search made and no email found. We also put in the record the reporting systems that the company maintains. Emails complaining of harassment are, on the first instance, supposed to go to your manager or to HR. If you're not comfortable emailing either one of those people, email another manager. If you're not comfortable making an in-person report like that, call an anonymous hotline, send an anonymous message through a website. She didn't do any of that. Whatever else she didn't email her manager, didn't email HR, she didn't take advantage of this online system. I think that evidence, when weighed in conjunction with her, what I would characterize as ultimately equivocal testimony about whether she definitely sent this email or not, that she said she had and then she
What
said
if,
she
what if
couldn't
she
find
had,
it.
what if she did definitely send it, but it turned out that something went haywire, as occasionally happens in an email system, and it could be proven that it was not delivered. But she definitely sent it. She wrote it up exactly as she said. We can prove that. I know that's not what the
Sure.
record shows here, but if it were, what result then?
Then maybe there's a fact question on whether Fossil should have known, but for its failure in its system. That doesn't get her past summary judgment. Ms. Harris also has to show that Fossil failed to take prompt remedial action. That's what she didn't do. That's what she can't do, because Fossil did take prompt remedial action.
If the error was that she accidentally typed the wrong character in the email address, and so it was a bounce back, and she didn't realize that. She definitely sent it, but to a mistaken email address. Would you say, well, in that case, as a matter of law, yes, she did, she in good faith did what she needed to do, but there's no way we could have known about it? Is that the
I think
point?
that's a close call. If those were the facts, I think that would be a very close call on the first element, or the first prong of the last element of the prima facie case. Again, that's not where the decision point is today. I would also, in that regard, point out Ms. Harris had plenty of other opportunities to bring this to the company's attention. She, by her own admission, she says that this behavior started in October and continued for months and months. She never brought that up to the company in any way, according to her, until she sent this email in late April. We assume that's true. That evidence comes into play a little bit later in this discussion, in the context of the affirmative defense to supervisor harassment. But the error on the part of the Dallas Court of Appeals was in
I
making...
think her response to that is that the company should have been on notice, given his earlier employment history. He was fired from Old Navy for harassment.
He may well have been.
So what's your response to that sort of, I guess it's a should have known argument? I'm not sure.
Well, it was two responses, Your Honor. One, at the time he applied, he was still working for Old Navy. And that's his resume is in the record, date of his application's in the record. There would have been no reason to ask him in the interview, hey, why did you get fired from Old Navy if you're still working for Old Navy, right? Two, though, that's a negligent hiring claim. And a negligent hiring claim is superseded by statute under this court's Waffle House opinion. And in fact, the plaintiff attempted to amend her pleadings below to add a cause of action very late in the day for negligent hiring. And the district court struck that pleading, one, because it was untimely, and two, because that's not a meritorious cause of action in this context. So there's no evidence that he had been, in fact, fired by Old Navy before he began working for us. The Court of Appeals, though, their only basis for finding a fact question on failure to take proper remedial action was somehow the email itself. Nothing else was presented to the court, and the court did no analysis of all of this evidence in the record. They just said, failed to take proper remedial action, fact question. And that can't be right. That can't be enough evidence to send this back to the trial court for trial. I'll reserve the rest of my argument for rebuttal.
Any other questions? Thank you, counsel.
Thank you,
We'll
Your
hear
Honor.
from the respondent.
May it please the court, Mr. Townend will present argument for respondent.
Chief Justice, Your Honors, thank you. I'm in an enviable position that I have a unanimous Court of Appeals opinion in my favor. There's no dissent. And with all due respect, I don't think there's any compelling unanswered question of law. This court has addressed on 2 occasions the applicability of the, I believe it's Farragut, if that's how you pronounce it, defense in City of Waco v. Lopez. That was an 08 decision. And in Waffle House versus Williams, that was 2010, they talked about the Farragut defense and its applicability. So, and I think there are a number of Court of Appeals decisions that address that. So I really don't understand, with all due respect, why the petition was granted. I mean, there's not an unanswered question. There's no dissent. The Court of Appeals got it right. And so I think the question.
So what evidence is there to create a fact issue on whether they promptly took appropriate remedial action?
Well, yeah, I guess that turns on.
I mean, to affirm here, we've got to look in this record and find some evidence that creates a genuine issue of material fact on whether they failed to take promptly take appropriate remedial action. Well, we know they took appropriate remedial action by firing Brown. I guess maybe there's a question whether that was prompt enough, but what evidence says it wasn't?
Yeah, so I think if you're just looking at when they had notice of Ms. Harris's actual complaint, you know, there's a tight timeline there. And I'm reasonably sure this guy was fired pretty quickly after that. But the Caitlin Kennedy thing had been going on for months. And the same vile harassment that was directed against her had been directed against my client, and they did nothing. And in fact,
But their position is that the earliest that they could have received notice of this is at the time that Ms. Harris sent her email. And as soon as they did receive notice, they promptly acted. And do you have evidence in the record that that someone in management authority had noticed sooner?
yes, there were 2, they called them store lock supervisors. They have like a key to the door, something like that. And one of them was named Cesarback. I don't recall the other one, but those 2 were aware of the problems with Ms. Caitlin Kennedy. And I think it was very murky as to when the store manager first learned about the Caitlin Kennedy things, because she was actually suspended for failing to take prompt remedial action. So I think the timeline that they contend is very murky in terms of when the Caitlin Kennedy information first surfaced. And it began to bubble to the surface right about the time when Ms. Zaborowicz spoke with my client.
Isn't the question, though, whether they took prompt remedial action with respect to the harassment of your client, not with respect to the harassment of somebody else?
Well, I guess you could slice it that thin, but I think when you have noticed that this guy's been a serial harasser, he's been harassing women in Old Navy.
But is there notice of that?
I believe in the evidence we had information that, well, the evidence was that they'd never asked the guy the question during the interview. He admitted, he testified that had they asked me, I would have told them, but nobody asked me. So exactly when they learned that, I can't tell you, you know?
So is it your position that an employer should ask when interviewing any potential candidate about whether or not they've ever been fired for harassment or?
Well, or why they were fired, why they were terminated.
But he wasn't terminated at that point, I thought.
I'm sorry?
He was not yet terminated.
Yeah.
So they're supposed to say,
You know-
are you busy harassing people in the job that you're still working? Is that what they have to ask?
Well, I think you know, if they're doing due diligence, I think they would want to finally get some confirmation of the reasons for his separation. He's going to be he's essentially the number 2 person at this store. There are a lot of women, young women working there, so I think it would behoove them to get some confirmation at some point in time of the reasons for his separation.
Well, aren't the reasons for his separation that they gave him a job? I mean, if he was working at Old Navy at the time that they interviewed him, you would expect that he would separate from Old Navy if he's coming to work for you.
Yeah, I guess that's reasonable.
So on May 2nd, she sent in her resignation, which I take it is a few days, a week, something. We don't quite know exactly when she went into their system and sent her notice to them. But in that resignation letter, which is quoted by the Court of Appeals, there isn't a hint that there's anything about the job other than she's working 3 jobs, it's stressful, she needs to stop juggling so much. Would it be reasonable to think that someone who would see this, if they hadn't seen that other thing, would say, okay, well, that's a very understandable reason to depart your job, but certainly I'm not on notice that there was something about this job other than the fact that you had 2 others and you're going to school, you're busy, blah, blah, blah. Isn't that a strange thing to see if she was actually quitting because of something so vile as what I think we all agree happened to her, no question about it.
I mean, this young lady's what, like 21 years old? You know, it's like a Christmas job. You know, she's just trying to get some extra money there, and then all of a sudden she's a victim of this stuff. I don't think she has anything in her life experience that trained her or taught her how to deal with this stuff. Certainly their harassment training didn't, you know.
But if she took advantage of that because they said, look, and there's the posters in the back room, all of this stuff, to say to people, look, this can happen. If it does, here's what to do. And if she actually did that, and then on May 2nd, she resigns without a hint of it, there's a lot of cognitive dissonance at the very least. You would surely agree to that.
Well,
as I said in my email, last week, this has become unbearable because of the way I'm being treated. And I've got 3 jobs, and,
with all due respect, she's not a lawyer. She's a young girl with life ahead of her. She doesn't have a lot of life experiences, and she was dealing with something that's horrendous. It's awful.
No question about
It's
that.
awful. So
There's no question about that. But the question, counsel, the question is, what is it that Fossil could have known? It's not whether this happened to her. I think everybody agrees that it did, and that it is absolutely horrendous and unforgivable. The question is, what could Fossil have known about it? And based upon what we're seeing in the record, I'm not sure really what that is. And I fully credit your point.
Yeah.
This is just an unfortunate reality that there are people who are harmed in ways and don't know perhaps the right way to proceed, even if people try to give them that.
Well,
but nonetheless, the question for us is, what is it that Fossil knew? How could it have responded
The best
differently?
evidence of that are the 2 other key supervisors and the store manager who were aware of the harassment against Caitlin Kennedy. That happened, we believe it happened months before her. And the other practical problem is none of this stuff was...
But the reporting all happened around the same time, right? The
Well-
reporting to the person that was hiring and firing for the store happened around the same time.
Well, I would...
As Ms. Harris's complaint.
Okay. What happened at her about the same time was she was resigning, and then the store manager came and spoke with my client. She had just resigned and wanted to talk to her about her issues, whatever those things were.
Right, and that was in response to, Fossil says in response to this other complaint that surfaced right around the same time your client made a complaint.
Well, that's the question. They kind of slough over that right about the same time because, again...
Well, your client said it was right before she resigned, she made the complaint, and then within that time frame of about a week or so, week and a half, maybe several days, this other complaint surfaced. And then, a day or 2 after your client resigned, somebody reaches out to her to say, tell me about what happened.
Yeah, I don't know that the summary judgment record is that tight and that clear about when these other 2 key supervisors were aware of not only this same stuff happening against Ms. Kennedy, but also the fact that they became aware that the same stuff was happening against my client. Now, they were not store managers, they were the key supervisors that opened the door. The point is there's at least summary judgment evidence that the knowledge of this was pretty pervasive. This was not an isolated event, and the acts were so awful that They talked about it, you know, and people were aware of it, not necessarily the top end, but anyway, that level of supervisors. And on a summary judgment, I think that's why you have trials. I mean, did they know or should have known it? This all comes out in the trial. Let them go prove to a jury that they didn't know. So I think the Court of Appeals got it correct. I don't think there's any real need for clarity in the law by this court. It's already done that in those two decisions, and there was no dissent, so unless somebody else has a question.
Well, so help me understand, what evidence were you able to present that the store manager had knowledge of the sexual harassment of Caitlin Kennedy months before the report made by your client? What evidence is in the record of that? Is that some kind of deposition testimony or a written statement?
We never were able to get Caitlin Kennedy's deposition. So based upon what my client's evidence was, she believed that had been ongoing for a couple of months and nothing had been done. And she believes the manager was aware of it. So
What does she base that on, or where does that come from?
I think it's probably store gossip. These ladies talk to one another, you know. Caitlin's, what's happening with your case? You know, that kind of thing. Nothing. So
I mean, I'm reading your petition for review here, page 15. Brown's misconduct was pervasive and widely known, as there is evidence that Harris and Kennedy, 2 co-workers, and 3 supervisors at Fossil knew of his misconduct. What evidence is that? That's what we're trying to figure out here, I think.
yeah, I in terms of the time, there's no question all three of them knew of it. Could I sit here and tell you exactly when all 3 knew of it? No, I couldn't. But there's evidence that all 3 did.
And we need evidence that, I assume a store manager would be enough. I don't think a coworker would be. I mean, if Miss Kennedy certainly knew about it, I don't think that's attributable to Fossil the company, but a store manager's knowledge would be.
Right.
But so what evidence do we have as to when the store manager knew that Mr. Brown was engaging in
I
this
couldn't
conduct?
parse that out now. I couldn't tell you when she knew of that.
You see the problem we have, right? I mean, we as Justice Young said, we get how horrendous this was, and Mr. Brown certainly ought to be paying the price. Sounds like maybe he is, but what you're asking is for Fossil to pay the price, and to make Fossil pay the price, you've got to show that under the law, there's some evidence to create a fact issue that under the law they can be held liable, and to do that, you've got to show they knew or should have known of this conduct sometime earlier than when they took the prompt action to respond to it.
If this were a trial, I would agree with you. In a summary judgment setting, I believe the burden is on them. And I think the burden is on them to establish this defense as a matter of law and establish when these things occurred and so on and so forth. And I don't believe they did. In fact, for the most part of their briefing, they ignored all the Caitlin Kennedy stuff as if it never happened. And, you know, they never attempted to show as a matter of law, okay, this is when we found out about Caitlin Kennedy, and this is why it wasn't relevant, et cetera. They just, I can't recall them mentioning it in their briefing.
Well, I think their position might be, well, they made a prima facie case of their defense as a matter of law by saying, you know, here's when we learned the information, or could have learned the information, and here's when the firing happened, and that was only a few days. And then wouldn't it then be up to you to offer evidence creating a fact issue that they learned earlier?
Yes, I would agree with that in that context, but I think I think we did that. I think we did create a fact question, but I don't know that they established their burden as a matter of law because they didn't address it.
I think they just now said that, assuming that the email was sent and they got it, the problem is the remedial action that was taken very quickly after that.
Yeah, and so we're talking about 2 different issues. The first defense, part of the prong of the defense talks about whether they knew or should have known of this misconduct. And I don't think it's, I don't think you judge that in the abstract of, well, let's just talk about whatever they knew about Harris, because what do they know about Caitlin Kennedy? What do they know about Old Navy? And so that's a part of the constellation of facts, whether they knew or should have known. And I think on those first two prongs, they just ignored it, in my opinion. Now, I'll agree with you. Once they found out about the email, they acted promptly or had already acted promptly. That's true.
Any other questions?
No, sir.
Thank you, counsel.
Good to see you again, Judge.
Nice to see
It's
you.
been a long time since the Athena Fire case.
Yeah. Mr. Barkis, I believe you have 5 minutes.
Thank you, Your Honor. Just a few brief points.
What is your answer to his answer just now about, he's talking about not just the email, but things that happened before that?
Well, the things that happened before that, if they didn't happen to Ms. Harris, they certainly don't give rise to any fact question about whether Fossil knew that Ms. Harris was being mistreated. There is also no evidence in the record of this notion that, well, counsel said we believe it happened to Ms. Kennedy months before. There's no evidence of that whatsoever. Fossil did not receive a
Looking
report.
at how this court has expressed the Farragher-Eller defense, the first element, it seems like it's about the employer's conduct, and it seems like in this case there's no dispute about the second piece of that, which is that there was a prompt correction of the harassing behavior. But before that, the law requires that the employer exercise reasonable care to prevent and correct promptly any behavior.
Right.
So we understand what the correction is here. He was fired and swiftly. But what does the duty to prevent the harassment entail? And what's the evidence that that was satisfied here? I mean, does it really boil down to you're fine if you, as a matter of law, if you just have a policy for anonymous reporting? Or is there something more?
There are cases that say you are fine as long as you have a robust policy for reporting, you communicate that to your employees, at which Fossil does and which Fossil did, and that wasn't disputed at all in the Court of Appeals. Their focus was on the second element of the Farragher defense, which is whether Ms. Harris unreasonably failed to take advantage of those opportunities. And the evidence is that she did unreasonably fail, and this can be decided as a matter of law. Again,
But how did she fail
Sure.
to take advantage of that if we credit her testimony that she sent the email?
Sure. She sent the email in late April. The harassment began in October. That's a delay of 5 months. And whatever the reason for the delay may have been, there is case law within and outside the Fifth Circuit saying that a delay as little as 2 months is undue delay as a matter of law. The Fifth Circuit case is Cassiano. It's cited in our brief. We've cited Williams'
You don't
case.
dispute whether it was at the time she made it or 5 months earlier, that the report creates an obligation to investigate and take prompt action if it turns out that the allegations made are true.
Sure. So we're kind of blending coworker and supervisor harassment. Supervisor harassment puts the onus on the front end on Fossil. Have a policy in place. And then it says to the employee, you can't delay in taking advantage of that if you want supervisor vicarious liability. So we did our part. Fossil did its part. Fossil has a robust program to prevent this sort of behavior. And
If there was evidence, though, that these key supervisors were aware of another employee being harassed, say 2 months earlier, then is the employer discharging its duty to take reasonable care to prevent harm to other employees if they do nothing about that?
So I'm glad you brought up what were referred to as the key supervisors. They're not key supervisors, they're key holders. That means exactly what it sounds like.
Okay,
They've
well,
got a
assume it
key to
was
the
a
front door of the store.
Just to get the legal, and I want to hear about that, but just to get the legal question clear, if there were evidence that a supervisor knew 2 months before all of this that happened within the span of a few days, that another employee in the store was being harassed and did nothing about it, then would that be some evidence that the employer failed to exercise reasonable care to prevent harm to other employees?
I guess it'd probably be fact-specific, but again, that's sort of a blending of the two strata, whether it's coworker or supervisor. But on the question of when is knowledge imputed to the company, which I think is very important here, it's imputed when somebody with the power to make a difference, somebody with the power to make a change gains that knowledge.
Is there any evidence that somebody like that knew about the allegations by whom the Court of Appeals refers to using the initials KK?
There is no such evidence. The only people who are alleged to have known about it and with any evidentiary support at all, and it's thin, are these two key holders.
And
two
at what point did
coworkers.
those key holders, when is there some probative evidence that the key holders knew about KK?
Well, that's when counsel referred to months before. I don't know more precisely than that. They didn't even report it to those key
I
holders.
thought there was some
delayed.
testimony that the outgoing store manager, Zabrowski or something, I can't remember, that she testified she had some knowledge with regard to Miss Kennedy.
There
Is that not right?
there was an outgoing store manager, I think her name was Brandy. Carey was the one who followed. Zaborowitz was the one who followed. And I think there is evidence in the record that Brandy may have been told something about something that happened to Kennedy, told by yet another person. That doesn't speak at all to anything that might have happened to Ms. Harris. And I don't think that's directly relevant, certainly on whether Fossil took prompt remedial action once it learned about harm being perpetrated on Ms. Harris, which is where the focus should remain today.
But when was that, the outgoing manager allegedly, or with some evidence, not just an allegation, had knowledge about Brown?
I don't have the date in my head, Your Honor. I'm happy to submit a letter with the date. It was, I mean, her whole period of employment was October of 18 through May 2nd of 19. So this is not a pattern of behavior over a course of years. This is.
Would you agree, though, that if the manager had knowledge of Brown in November about what Brown was doing to another employee, that would be quite a different thing?
Absolutely.
Than if they got that knowledge at the end of April or beginning of May or something?
Absolutely.
Okay.
Any other questions? Thank you, Mr. Marcus.
Thank you, Your Honor.
Case is submitted. That concludes the arguments in the cases set for today, and the marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.